Welcome to The WorkPlace, a podcast by CalChamber. I'm Matthew Roberts, Associate General Counsel for Labor and Employment with the California Chamber of Commerce. Hello, listeners. We are headed rapidly into the final quarter of the year, and one of those checklist items at this point of the year is making sure we have completed our mandatory harassment prevention training if we are currently in our training year. Now, amongst the several required topics that we discuss in our trainings, misunderstandings can often arise about whether a single instance of harassing conduct is ever enough to be an issue, or whether that conduct that occurs after hours away from the workplace, like say on a personal social media, is even covered by the law or our employer policies. Well, we just recently got two very instructive cases that help put a real-life spotlight on some of these more complex workplace harassment issues. And to discuss these cases, we welcome back a fellow trainer and CalChamber's employment law subject matter expert, Vanessa Green. Thanks for joining me today, Vanessa.
Thank you for inviting me, Matthew.
So, Vanessa, we got two cases, one primarily focusing on a single instance of harassing conduct, and another focusing on whether personal social media use can come into the workplace and then be something that we need to handle as employers. Both very fascinating cases, especially factually for us, and quite instructive for our listeners. So let's start with the single instance harassment case. This case, titled Bailey versus the District Attorney Office of San Francisco, focuses on really that second part of a hostile work environment claim. That is, whether the conduct that actually happened was sufficiently severe or pervasive to constitute unlawful harassment. Vanessa, what's the underlying act that gave rise to this claim?
Yeah, so back in January of 2015, Tawanda Bailey, who worked at the San Francisco District Attorney's Office, had a pretty awful experience when her coworker named Saras Larkin referred to her using the N-word. And Bailey, who's African American, was really upset. She told a few coworkers at the time about what happened, but she didn't go straight to the personnel officer who was responsible for handling workplace complaints. Why, you might ask, didn't she go to the personnel officer? Well, she was afraid of retaliation, particularly because Larkin, who used the slur, had a close relationship with the personnel officer. So Bailey's supervisor eventually heard about what happened and reported the incident to the personnel officer. So Bailey then met with her supervisor and the personnel officer to discuss the incident, and in that meeting, Bailey confirmed that she did find what Larkin said offensive, and also that it was the first time that something like this had happened. So Larkin, who denied making the slur, was counseled on the city's harassment policy, and then nothing more was done.
Okay, so obviously we're kind of starting off with a banger here, right, Vanessa? You hear the N-word, and I think a lot of people just kind of internally cringe because we know the historical context and how really offensive that word is. And that should be a pretty big problem in the workplace. So then that raises the question, why are we even here in this case? Shouldn't have this been a problem? But I wanted to highlight something that you just mentioned, is that this really only occurred once, right? And then never happened again. So there wasn't this pattern of behavior. It was just a one-off, essentially, right?
Yep, this only occurred once, and that can matter. I mean, one act, it can be enough to become unlawful harassment, but it has to be severe enough.
Okay, so then it does matter that, it just occurred once. So let's talk about that severe matter. So the city eventually gets this, right? The city of San Francisco gets this and looks into this. What conclusion did they come to when they're looking at this severity of the conduct?
So they concluded that because it was a single incident, that even though the N-word is undeniably offensive, being a single incident, it wasn't enough to create a hostile work environment, according to the city.
Yeah, and that's the part that I think really sticks hard to me, because I know when you and I go train employers on this issue, we tell them, look, there's the severity of it under the law, but there's also your employer policy, right? Most employers maintain the zero tolerance policy, which would just find we're not going to allow this to happen, whether or not it's quote unquote sufficiently severe under the law. But I really found that fascinating that they still got to that stage that it just wasn't even severe enough for them. But as this case shows, the California Supreme Court saw it differently from everyone else, because I know the city saw it as not sufficiently severe. The lower court saw it as not sufficiently severe. So why did the California Supreme Court reverse everybody and say, no, this one-time use of the N-word, this racial slur, is absolutely severe enough to be unlawful harassment?
Yeah, so when the Supreme Court was looking at the severity, it looked at the totality of the circumstances. And so, in other words, it was looking at would a reasonable African American like Bailey in her position find the use of the N word to create a hostile work environment? So it looked at all of the different factors involved. It looked at the fact that the N word has this historical weight, like you mentioned earlier, that makes it really deeply harmful. And if it's spoken even by a coworker, not necessarily a superior, if there's a really small shared workplace like Bailey worked in, that can be really severe. So the court looked at that. It also looked at Larkin, who used the slur, that employee's close relationship with the personnel officer, which it said could have given Larkin kind of an undue power over Bailey, making the situation even worse. And so it looked at the totality of the circumstances and not just the fact that it was a one-time incident.
Yeah, and so that's why I find this very interesting that the California Supreme Court kind of seemed to look at this with clear, open eyes and say, okay, like, what is the conduct we're dealing with? What is the circumstance of this case? And can somebody in the shoes of Bailey think that this is reasonably offensive? And I think we all kind of get there, Vanessa. But I want to touch back again on that zero tolerance policy, because this is why it's so important. You know, if you see a situation there and you try and judge these things by the legal standards of, is it sufficiently severe or is it pervasive? That is, does the conduct keep happening over and over and over again to the point where it's just problematic? Then there may be instances where you're not taking those reasonable steps you have to take to prevent the future instances of harassment. And Vanessa, that's really what the zero tolerance policy is about, right?
Absolutely.
Okay. Now, what's really interesting here, I think, and something else that's good to discuss in this context is that Bailey also had this retaliation claim, right? You mentioned that, you know, somehow this got to the personnel officer through Bailey's supervisor, and the personnel officer still decided not to do anything, and I think Bailey raised this as an issue. Vanessa, on this, what was the basis of Bailey's retaliation claim after she brought the information forward to her superiors?
So Bailey, after the personnel officer found out about Bailey's claim, Bailey noticed that the personnel officer started treating her with more hostility and more negatively. So one example was that the personnel officer chastised Bailey for telling her coworkers about the incident. Then there was another situation that occurred in the parking lot where Bailey claimed that the personnel officer made a threatening gesture at her. And then, like you mentioned, Matt, I mean, the fact that the personnel officer was supposed to file an official complaint, but never actually did, was another thing that Bailey contested was retaliatory.
So this is interesting, Vanessa, then, because I know when we talk about retaliation, you know, individuals are usually concerned about, if I complain about something at the workplace, I'm going to be fired because I'm raising hell, essentially, at the workplace. But that's not all retaliation can come through, right? What does retaliation really look like in this context to you, Vanessa?
Yeah, so retaliation, it's not just about being fired, it's really some kind of adverse employment action. And that can be like Bailey, you know, went through a situation where she's being treated hostilely, negatively. Maybe coworkers are shunning her, right? We see those things all the time, probably even more common than people being fired for retaliation. We see situations where people are shunned or ostracized by their coworkers, and that's just as much retaliation as it is them losing their job.
Okay, wonderful. So I think Bailey's case is really instructive on a couple points there for us. Obviously, you know, the importance of a zero tolerance policy, whether it's severe or not, because again, just one instance can be a problem there at the workplace. And then, you know, making sure that this retaliatory behavior in all of its forms is not occurring when somebody comes forward with a protected activity. So then let's move to the next case, titled Okanowski versus Garland. Now, this case involved a prison psychologist and a corrections officer lieutenant. Those are kind of the main characters of this story. And it seems that they butted heads about job duties and the treatment of inmates. And eventually this led the lieutenant to create a social media account. So this is fun, right, Vanessa? Because we always have this issue like, hey, if this conduct doesn't happen at the workplace and the employer has no control over it and nothing can happen. And so that's where social media has kind of turned all this upside down on its head, because social media is omnipresent. It's everywhere, inside, outside the workplace, inside, outside our lives. So, Vanessa, discuss the details of what the lieutenant was posting to this account.
Yeah, this is so cringy, Matt. So he
Mm-hmm.
had posts with really offensive content, things that were sexist, racist, violent, and in particular, a post that targeted the plaintiff, Lindsay Okanowski, in this case, and depicted really suggested violence at her, sexual assault towards her, like really disturbing and threatening scenarios towards her. And what makes it even cringier is that despite the graphic nature of these posts, many of Hellman's coworkers, including upper management, were following and liking and even commenting on these posts.
So what's interesting about this, right, is that the posts are targeting the plaintiff and, other women at the prison facility. But how did Okanowski learn about these posts?
Yeah, so interesting. It turns out that some algorithm in Instagram suggested this as an account that she should follow. And so she started following the account, and that was where she realized the content of the post and the nature towards her.
So this is one of those audience things, right? Okanowski becomes an audience member, basically somebody who this conduct is now directed towards. And unlike Bailey, Okanowski actually did take her complaints to higher ups personally, right? How did that all turn out?
She did. She took her complaint to multiple people higher up, including the human resources manager, and she was told to quote unquote toughen up and get a sense of humor. And even some people told her, come on, these posts are funny. It really wasn't until several months later, when the prison ended up getting a new warden, that her complaint was actually taken seriously.
So I find it interesting. We have these two cases. We have Bailey and we have Okanowski, and they're resolved close in time, right? We've got these opinions pretty close to each other. And they both seem to have factual scenarios where the employers are falling short in that initial investigation, right? The conduct towards Bailey gets to the right person, or at least supposedly the right person, to conduct an investigation. Nothing happens. Okanowski takes it directly to everybody that she wants to, and nothing happens. So, Vanessa, why is this such an important part of a harassment prevention policy or protocol for employers to engage in these initial investigations?
Matt, it is so important, and we see this time and time again. And employers really need to understand that there's both legal and practical reasons why they need to investigate and take these things seriously. I mean, legally, employers are required to investigate, but it's not just about the legal checking the box. Practically, it's about getting to the facts so we can prevent future instances of harassment in our workplace. And if we don't do that, we're putting our employees at risk, and we're potentially damaging our work environment.
So something that struck me about this case, kind of a lot like the Bailey case, is that the lower court decided that there's nothing unlawful at the end of the day here with this conduct. And I think that gives us some pause, because we've got some pretty egregious conduct that's finding its way to individuals who are at the worksite who feel offended enough to complain about it or be upset by it. In particular, the trial court took pains to show that because this was a personal social media account, this really shouldn't follow under our harassment rules. Now, the Ninth Circuit disagreed. Why is that, Vanessa?
Well, the Ninth Circuit said, look, it's not about when or where the conduct occurs so much as who the audience is. And in this situation, the audience was Okanowski and her coworkers, and that ended up carrying over into the workplace. It created an environment where she didn't feel safe and comfortable to go to work because of these posts that were happening on Instagram.
And that's what's really important, because even the Ninth Circuit entertained this idea, right, that maybe Hellman, the lieutenant, was making these posts after hours and off the job, although they kind of suspected that that wasn't the case because there were so many posts that happened in this short period of time. But that didn't seem to matter to the Ninth Circuit, right, the time of day that these posts were being performed, right?
No, it didn't matter to the Ninth Circuit. They really weren't looking at the time of day or when or where the posts were occurring. It was all about who was involved and who could see these posts, who was the audience, and how it carried over into the workplace.
Awesome. Well, Vanessa, thank you very much for taking some time today to discuss these recent cases with me. It's always fascinating that we continue to learn and get new guidance, even in areas of law that are as well established as workplace harassment. So I think these were very instructive for both the employers enforcing their policies and highlighting how, vital, effective, interactive training is in this area of the law. So thank you for joining me today, Vanessa.
Absolutely. Appreciate you having me, Matt.
And thank you, listeners, for joining this discussion on the workplace. Please share and subscribe to CalChamber's podcast by visiting calchamber.com.